Good morning, good afternoon. I'm Lisa Sotto, and I chair the Global Privacy and Cybersecurity practice at Hunton Andrews Kurth. And I'm delighted to welcome you to today's webinar on the practical implications of last week's rather stunning Schrems II decision. As we all know by now, the Court of Justice of the European Union opined on the two primary mechanisms that companies use to legally transfer personal data out of the EU to third countries. And with respect to standard contractual clauses, the court held that SCCs continue to be a valid mechanism for businesses to use to transfer personal data from the EU to third countries that are not deemed to have adequate data protection laws in place. But the court wasn't content to leave it at that, and instead the court imposed significant additional burdens on companies that transfer data on the basis of SCCs, and we'll talk all about those burdens during this session. The court was less generous with the Privacy Shield and deemed the Privacy Shield to be invalid, effective immediately. So unfortunately, this was, and I can't believe I'm using past tense here, but the Privacy Shield was a mechanism that allowed nearly 5,400 companies in the US to transfer personal data legally from the EU to the US. So the Privacy Shield is gone, at least in its current incarnation. And it wouldn't really be an overstatement, I think, to say that we in the privacy community are still reeling over the effects of the ruling. So let's get on with the discussion. I'd like everybody to be aware that the program is being recorded, and we will make the recording available after the program. And if you have questions, please use the Q&A feature at the bottom of your screen to submit questions. And if time permits, we will answer them at the end of the program. So I'd like to introduce our speakers for this session. Joining me for the next hour are David Dumont. David is a partner in Hunton's Brussels office, and he has worked with multinational businesses on all aspects of EU data protection law and has extensive experience helping clients with cross-border transfer mechanisms, including standard contractual clauses and BCRs. Bridget Treacy is a partner in Hunton's London office, and Bridget has extensive experience advising on all aspects of privacy and data protection for multinational companies across a broad range of industry sectors, which is very, very important because we need to think across industry sector. Aaron Simpson is a partner in our New York office, and he brings a unique transatlantic perspective to this conversation. Aaron spent the years running up to the GDPR as the managing partner of the firm's London office and head of our European data protection team. And Bojana Bellamy is also joining us. Bojana is the president of Hunton's Center for Information Policy Leadership, which is a preeminent global information policy think tank. Bojana also was the recipient of the 2019 IAPP Vanguard Award, and prior to joining CIPL, she served for a dozen years as the Global Director of Data Privacy at Accenture. So to provide some perspective on who we are and our viewpoint, which of course is reasonably unique, we are about 50 privacy professionals in the US, the EU, and Asia, and we represent clients across industry sectors, so we can compare from sector to sector. I would commend you to both the CIPL website that has really tremendously important policy papers that are available open source, as well as our blog at huntonprivacyblog.com. And we would not be a complete privacy practice without a Twitter handle, so there it is on your screen. Next slide, please. So today we're going to be talking to you about the both Schrems I and Schrems II decisions. They're both, they inform each other. We'll talk then about the ruling specifically with respect to standard contractual clauses. Then we'll take up the Privacy Shield and give you some operational tips for going forward. How do we do this? How do we operationalize this decision? And then Bojana will kick in with some global policy considerations. So with that, we're going to begin our program with David Dumont, who's going to provide a summary of the case background. David, over to you.
Thanks, Lisa. Before diving into last week's ruling of the Court of Justice and its implications, I want to take just a couple of minutes to go back in time and highlight some important events that have actually brought us to where we are now. And we need to go back quite a number of years, more than 7 to be precise, because the series of events that resulted in last week's judgment was actually triggered when Edward Snowden revealed that the U.S. National Security Agency was conducting mass surveillance, including through the so-called PRISM program, and that happened in June 2013. In the immediate aftermath of these revelations, Max Schrems, an Austrian privacy advocate who was still a law student at that time, decided to file a complaint with the Irish Data Protection Authority, as he was concerned that data of EU Facebook users, including his own personal data, were transferred to servers located in the States, where, based on the Snowden revelations, the law did not offer sufficient protection against government surveillance. In light of that, he asked the Irish Data Protection Authority to order Facebook Ireland to cease the transfer of personal data to its parent company in the States. And the Irish Data Protection Authority rejected this complaint, taking the view that it was not in a position to investigate the transfer, as Facebook was certified under the so-called Safe Harbor framework, which was recognized by the European Commission as providing an adequate level of protection, and which, as all of you probably remember, was the predecessor of the EU-US Privacy Shield. Max Schrems was not satisfied with this result, and he initiated judicial proceedings with the Irish High Court. And in the context of these proceedings, the Irish High Court decided to refer a number of prejudicial questions to the Court of Justice of the European Union. In short, the Irish High Court asked the Court of Justice to determine whether a data protection authority is bound by an adequacy finding of the European Commission, or whether, when it receives a complaint, it may or even must investigate international data transfers, regardless of the fact that it is based on an adequacy decision of the European Commission. And this referral resulted in the first landmark judgment in the so-called Schrems I case on October 6, 2015, a date we probably all still remember as the date where the Court of Justice decided to strike down the Safe Harbor framework. Following this decision, the Irish Data Protection Authority asked Mr. Schrems to reformulate his initial complaint, dating back from 2013, as Facebook was no longer relying on the Safe Harbor framework to transfer user data to the States. And at that point in time, Mr. Schrems decided to challenge the validity of the EU controller to processor standard contractual clauses, as this was the alternative transfer mechanism that Facebook had put in place to legitimize its EU-US data flows. Similar to the challenges he raised with respect to the Safe Harbor framework, the key concern was that EU personal data might be at risk of being accessed by the US authorities in a way that is not compatible with privacy rights guaranteed in the EU, and that there are not sufficient remedies available to EU individuals to ensure protection of their personal data after it has been transferred to the United States. While the Irish Data Protection Authority was investigating this reformulated complaint, the EU-US Privacy Shield framework was adopted on July 12, 2016, to replace the invalidated Safe Harbor framework. The EU-US Privacy Shield framework is, or should I say, was, a similar certification-based framework as the Safe Harbor, but now with additional protections aimed at resolving some of the issues that were raised by the Court of Justice in the Schrems I ruling. After investigating Mr. Schrems' reformulated complaint, now focused on the standard contractual clauses, the Irish Data Protection Authority decided to bring proceedings against Facebook in the Irish High Court, which in turn referred 11 questions to the Court of Justice for a preliminary ruling. And these prejudicial questions primarily addressed the validity of the standard contractual clauses, but they also touched upon the newly adopted EU-US Privacy Shield framework. More than 2 years later, in December 2019, we were reminded of this pending case when the Advocate General issued his opinion. And in this opinion, the Advocate General recommended the court to uphold the validity of the Standard Contractual Clauses as a transfer mechanism. And with respect to the EU-US Privacy Shield, the Advocate General raised a number of concerns in his opinion, but he explicitly advised the Court of Justice not to rule on the validity of the shield, as this was not necessary to decide in the pending matter. Last week, July 16, 2020, another date that privacy professionals will likely never forget, the Court of Justice issued its second landmark judgment in the Schrems case. And the court, in line with the Advocate General's opinion, concluded that the Standard Contractual Clauses as such remain a valid data transfer mechanism, but surprisingly, the court decided to strike down the EU-US Privacy Shield framework. And with that, I'll turn it to Bridget to start a deeper dive into the court's ruling and its implications.
Thank you very much, David. And before actually looking at what the judgment held in relation to standard contractual clauses, I just want to pause for a minute and actually just think beyond the headline summary. We know the headline for the case was Privacy Shield invalid, SCCs valid but with caveats. But if we look beyond that and actually read the judgment, I think we can see that the outcome of the case is actually consistent with Europe's approach to data protection. So from an EU perspective, European legal safeguards for personal data are effectively exported along with the data export. Transferring data abroad doesn't somehow mean that European data protection safeguards are lost. And that's where the key challenge arises. How do we address conflicting legal requirements that may exist in other jurisdictions? Now, the Privacy Shield sought to do that, and as Lisa Sotto will explain, there is certainly a willingness on both sides of the Atlantic to try and find another solution. But for now, however, the practical result of Schrems II is that transferring data from the EU is going to be subject to much closer scrutiny from regulators and from privacy advocates. And data exporters and importers will need to prepare for this. And as we'll see, Schrems requires data exporters to take a much more proactive role in ensuring adequate safeguards for the EU data that they send abroad. Let's turn now to an overview of the judgment and consider what the court said about standard contractual clauses and what this means. So first, I just want to say that it's extremely helpful that the standard contractual clauses continue to be a valid transfer mechanism. They're obviously a key mechanism for transfers from the EU and the UK, but not just to the US, to countries around the globe. And some service providers have actually signed many thousands of these clauses. Some companies have complex intragroup transfer mechanisms based on standard contractual clauses, so it really is very helpful that they remain valid in principle. However, the validity of the clauses comes with a caveat. We now cannot assume that the clauses automatically provide adequate safeguards in every situation. The court confirmed that the clauses are valid, and I'm quoting, in situations where the recipient can guarantee protection of the data solely on the basis of the clauses, end quote. However, the court emphasized that in other cases, the clauses may not be enough. And the Schrems case provides an example of this, where the law in the importing jurisdiction allows public authorities to access the data in a way that might interfere with the rights of European individuals. So here, obviously, the contractual safeguards don't bind a third party, the public authority, so additional safeguards need to be investigated. Now, to determine whether the clauses are sufficient or whether we need these additional safeguards on top, the exporter needs to consider its transfers on a case-by-case basis. And the focus of this assessment is to verify whether the law of the importing jurisdiction ensures adequate protection under EU law. So it's an EU standard. The exporter needs to consider then whether the standard contractual clauses can address any shortcomings or whether they need to be supplemented. We call this process of analysis and risk assessment a transfer risk assessment. And as many of you will have realized already, a transfer risk assessment places a huge and somewhat unrealistic burden on exporters who, even in ordinary times, let alone during a pandemic, are unlikely to have the resources to assess the laws of other jurisdictions. Given that standard contractual clauses are not just used for transatlantic transfers, but for transfers around the globe, potentially this means that the laws of some subset of 200 or so countries need to be assessed. Aaron Simpson will discuss the practicalities of this transfer risk assessment in more detail. And just a final point on this slide here, the court also emphasized that if there is no adequacy, then the transfers need to be suspended. So initially it's for the exporter to determine this, but if the regulator is investigating, perhaps on the back of a complaint, and the regulator concludes that there is insufficient adequacy or safeguards, then the regulator needs to ensure that rule that the transfer should be suspended. So while the judgment increases the workload of data exporters, it also highlights the role of the regulators to ensure that the transfer requirements of the GDPR are met. Now, looking ahead, I think what we can be sure about is that transfers from the EU will be subject to much greater scrutiny. To understand why and what is now required in terms of this transfer risk assessment, I think it's helpful just to take a minute or two and just to revisit the European data transfer framework. So, moving forward, the starting point in assessing this is to remember that in the GDPR, there's a general prohibition on transfers abroad unless the conditions of Chapter 5 of the GDPR are complied with. And the objective here is clearly to ensure that the level of protection guaranteed by the GDPR and by the underlying Charter of Fundamental Rights are not lost by sending data abroad. How is that achieved? Well, there are three key ways in which this European level of protection can be assured when the data are exported. The first is an adequacy determination, and here it's the Commission's job to undertake a detailed review to determine whether a specific country, territory, or sector ensures adequate protection. And Privacy Shield was an adequacy determination. And just to be clear here, and this comes from the first Schrems case, the Court of Justice has confirmed that adequacy means essentially equivalent. So when assessing adequacy, the Commission conducts a very detailed and thorough examination of the legislation of the third country. It takes into account, among other things, the relevant legislation on national security and also public authorities' access to personal data. An adequacy decision is a binding decision. It can only be adopted by the Commission if the Commission has found that the relevant country provides the necessary guarantees. These assessments take time. They're a lengthy process. And with only one exception, the Commission's adequacy determinations have all taken more than a year. Once awarded, they can only be challenged in the court. And until Schrems I, there were no challenges. But in light of the issues raised in Schrems II, there seems to be every prospect that other adequacy determinations will be reviewed. So if there's no Commission adequacy determination, the transfer can still proceed, and I've moved to the second column, if there are appropriate safeguards. This requires appropriate safeguards, enforceable individual rights, and effective remedies for individuals. Now, examples of appropriate safeguards include, as we know, standard contractual clauses, BCRs, ad hoc clauses, codes of conduct, and certification mechanisms. And the last two are new under the GDPR. They are not currently available, and it remains to be seen whether they are revisited, perhaps in the wake of the Schrems judgment. So as we have already discussed, the standard contractual clauses are still valid as an appropriate safeguard, but we need to consider, or the exporter needs to consider, whether they are sufficient in the particular circumstances. And on this, the court was particularly clear that as for a Commission adequacy assessment, so they align the standard for appropriate safeguards with the standard under the adequacy determination, the appropriate safeguards must ensure essentially equivalent protections for data as under European law. I just want to make an aside comment here. We should note that BCRs are also a way of ensuring appropriate safeguards. They're not specifically addressed in the judgment, but it's entirely possible that regulators may require a transfer risk assessment for BCRs. Perhaps not so much so for controller BCRs, but possibly where European controllers send data to a vendor who relies on processor BCRs. And then the third column, derogations. These complete the picture. They are exceptional. The court specifically referenced them. Really, the derogations are a last resort. They're available where there's no adequacy decision and no appropriate safeguards, and they are intended to apply to specific transfers only. So moving on to the next slide. With that background, I think we can more readily appreciate that the objective of both the adequacy assessment that the Commission undertakes and the appropriate safeguards is to ensure there's continuity of a European adequate level of protection for the European data, even where it's transferred abroad. And as we've seen, the Commission takes on this task of assessing the legal framework of another country when it does its adequacy assessment under Article 45. But where appropriate safeguards are relied on, this judgment effectively asks the data exporter to undertake a similar assessment in each case, and that's extremely onerous. Further, the judgment is clear that we can no longer rely on the appropriate safeguards as being sufficient in every case. Now we know that they might be sufficient depending on where the data is going and what the laws of the importing country provide. So in effect, standard contractual clauses and by implication, other means of adducing appropriate safeguards can only be regarded as minimum baseline safeguards applicable in every case. Exporters now need to consider whether they need to be supplemented in each case. And that's the purpose of the transfer risk assessment, which Aaron Simpson will discuss shortly. I'd like to move forward now and just offer a couple of brief comments on enforcement. So next slide, please. We've found that many clients, as they think about their next steps, have asked questions about enforcement. And I just wanted to share with you a couple of questions that are asked most commonly. The first one is, how quickly do they need to act? And the answer is, if you were relying on the shield, which is now invalid and can't be relied on as a transfer mechanism, you need to act promptly, and Lisa Sotto will elaborate on this. But if you were relying on the standard contractual clauses, they remain valid, but as we've discussed, you'll need to undertake a transfer risk assessment. Is there any period of grace? Well, there's been no indication yet that the regulators will allow any time to implement alternative transfer arrangements, but after the first Schrems judgment, when the safe harbour was invalidated, there was an informal grace period of 3 months. Just a note of caution, if there is a grace period, it can't stop individuals complaining to regulators, and regulators are bound to investigate complaints. So it's possible that a supervisory authority in those circumstances could suspend a transfer, and indeed it would if it concluded that there were no appropriate safeguards. And what about sanctions? The most likely sanction here would be an order to suspend data flows, which could be particularly disruptive. And that might be a temporary suspension to enable safeguards to be implemented, or it could be more permanent. Fines are also available at the higher level, but these seem unlikely to be imposed immediately. And then just finally, just a couple of quick words on Brexit. We've also been asked about the implications for Brexit. The position is that the UK has now left the EU and we're in a transition period until the end of the calendar year. So this judgment will continue to form part of UK law beyond that date. From the 1st of January next year, transfers of data from the UK abroad to non-adequate jurisdictions that rely on standard contractual clauses will also need a transfer risk assessment. And the relevant standard when assessing the level of protection under UK law will be whether the protections are essentially equivalent to UK rather than EU law, which at the moment is the same. For transfers from the EU to the UK, as things stand, the UK doesn't have an adequacy determination from the Commission. Most European companies are preparing to use standard contractual clauses from the 1st of January to maintain their transfers to the UK. In light of Schrems, they'll have to undertake the additional task of assessing whether the clauses by themselves offer sufficient safeguards for transfers here. In relation to the UK's request for adequacy, it's possible, in light of this judgment and the criticisms of the Privacy Shield, that the Commission might be a bit more conservative in assessing adequacy. But it should be noted that the UK surveillance regime is different to the US regime. Finally, the UK government has expressed its disappointment in the judgment, and it is possible that the UK might in future take legislative action to allow a more flexible transfer regime, but that's just speculation on my part. Okay, I'm now going to turn the mic to Lisa Sotto, who will discuss the impact of the judgment on the Privacy Shield.
Okay, as Bridget said, this was the headline in the press. So, as David mentioned earlier, let's go on to the next slide, please. The Safe Harbor, which was the predecessor framework to the Shield, was invalidated in 2005 in the Schrems I decision. And I think it's notable what the court said there, so I'm going to repeat it. First, the court said that the Safe Harbor framework did not restrict the US government's ability to collect personal data of EU data subjects. And second, the framework did not grant EU individuals sufficient legal remedies when their personal data was collected by the US government. And these themes, of course, sound very, very familiar. They're nearly identical to the themes that we see in Schrems II, which we'll talk about in just a bit. So back in 2016, following a period of intense negotiation between the US government and the European Commission, the Privacy Shield was released to great fanfare as a successor framework to the Safe Harbor. And I honestly remember the days well when the Safe Harbor was invalidated and then when the Shield came out. It was, those were interesting days, just as interesting as last Thursday. So the Shield was intended to address the perceived shortcomings that had led to the downfall of the Safe Harbor. And although the Shield principles were really comparable to those in the Safe Harbor, the Shield was really an up-to-date version, and it was really considered to be very modern, very current in its thinking. And in addition to that, to help ensure that it was functioning as the relevant government parties had anticipated in their negotiations, there was a requirement built in for annual reviews. And there have been 3 successful annual reviews to date. So fast forward to 2020, and we have almost 5,400 organizations that are certified to the Shield. And it's really quite notable in my view that 70% are small and medium-sized businesses with fewer than 500 employees. This has been a very important data transfer mechanism, particularly for smaller businesses. It was scalable. And these businesses, of course, don't have the resources to enter into standard contractual clauses over and over and over again. Next slide, please. So I just want to note, I think it's really important to indicate that the FTC has not been lax in enforcing the Shield. The Commission brought over 20 Shield enforcement actions in just a few short years. They brought these, of course, pursuant to the Commission's Section 5 authority for alleged misrepresentations related to the Shield. And importantly, very recently, the FTC really stepped up its game in the NTT matter. And this was a very recent pronouncement on June 30th against NTT, which is the successor in interest to Raging Wire. So in this case, the FTC alleged that Raging Wire misrepresented its participation in the Shield and its compliance with the Shield principles, and also failed to comply with various substantive obligations under the Shield. And here's the game-changing part is, game-changing in also pointing out substantive violations, but also, very important, the proposed settlement really changed the name of the game for Shield enforcement actions by the FTC, because the FTC here requires NTT to obtain an annual outside compliance review from an independent third-party assessor regarding its Shield practices and assertions. Now, this doesn't sound so strange with respect to FTC actions. We see a lot of these sorts of requirements for annual assessments or biennial assessments by the FTC, but this is the first time in a Privacy Shield case. So very, very important. And of course, the date is very interesting, June 30th. Next slide, please. So let's get to it, the ruling. So really, this was quite an unexpected ruling, although as I think Bridget said earlier, you know, if you had really thought about it, it maybe not so unexpected, but I will say that I didn't expect it. So toward the end of what was a very lengthy decision, the court declared the Privacy Shield invalid. And the court repeated the very same themes that we heard in the Schrems I case, which was the case that torpedoed the safe harbor. And what the court said is that because US public authorities could access EU personal data that was transferred to the US via the Shield, beyond that which was strictly necessary being an important term here, the Shield did not meet the requirement of essential equivalence under EU law. The court specifically identified a provision in the Shield indicating that adherence to the Shield principles may be limited, and here I'm quoting, to the extent necessary to meet national security or law enforcement requirements. So what the court said is that this meant that national security rules took precedence over the safe harbor principles, and certified entities were therefore able to disregard the Shield principles where they conflicted with US law enforcement requirements. And this interfered with the fundamental rights of EU persons. So in short, the court held that US surveillance rules do not limit the collection of personal data to what is strictly necessary and proportional as is required under EU law. Next slide, please. The alleged overcollection of data in the law enforcement context wasn't the only failing that the court pointed out. In addition, pursuant to EU law, EU citizens have a right to an effective remedy before an independent and impartial tribunal. And in fact, the GDPR itself requires, and I'm quoting here, effective administrative and judicial redress for data subjects whose data is being transferred to a third country. So the court found that EU citizens don't have actionable judicial recourse against US intelligence authorities and therefore do not have a right to an effective remedy in the United States. And if we recall, the ombudsperson role that was implemented in connection with establishing the Shield, very important role in ensuring redress for aggrieved EU citizens. But the court indicated that the ombudsperson is not an independent and impartial tribunal and therefore doesn't provide EU citizens with the rights that are essentially equivalent to those provided by EU law. Next slide, please. So what now? You know, we're in a bit of a quandary. So organizations that relied on the Privacy Shield need to transfer EU personal data to the US, right? Period. They need to do it. So they need to quickly move to standard contractual clauses. There really are no other options. And I just want to note here that in declaring the Shield invalid, the court stated that this would not create a legal vacuum. Interesting statement there, because companies could rely on the derogations that are provided in Article 49 of the GDPR. But this is highly problematic because the derogations, and this includes consent, for example, are explicitly intended only for occasional non-repetitive transfers that involve a limited number of data subjects. So the derogations just don't work for ongoing normal business transfers. So where do we stand now with the Shield? The Department of Commerce has said that it intends to continue administering and enforcing the Shield. Secretary Ross put out a statement expressing deep disappointment in the CJEU decision. And the press release said that Commerce will remain in close contact with the European Commission and with the EDPB. And they hope to be able to limit negative consequences, and Commerce threw out the number of $7.1 trillion as the number that is the economic imperative for pushing this forward. This is the basis for the transatlantic economic relationship. So invoking a very large dollar number here to hopefully move this conversation forward. So Commerce has specifically said that it hopes to renegotiate the existing SHIELD framework. And I'll also note that Commissioner Jourova of the European Commission also said that, that they were in talks with their US counterparts about next steps. And what she said is that we will not be starting from scratch, but that an updated tool will be fully in line with the Schrems decision. So of course, this means that the surveillance issues will need to be addressed. This is not susceptible necessarily to an easy fix. And also the US is going to need to ensure sufficient judicial redress, not the ombudsperson that sits in the Department of State, but judicial redress for EU individuals. The Commission, in my view, does seem wedded to the SHIELD, so I think there is some hope for renegotiation, but we're in a wait and see mode, and we'll need to reevaluate pretty much constantly. I'll also note that the UK Information Commissioner advised that those entities that are currently relying on the SHIELD should continue to do so for their existing transfers. So in short, we're generally advising SHIELD certified organizations to not abandon their SHIELD certifications at this time. Of course, this advice may change next week, next month, but the fact is that certified entities need to comply with their SHIELD commitments anyway for data that they collected via the SHIELD. So why not keep it in place a bit longer to see how things shake out? But regardless, companies will need to take action now in the immediate term. So I'm going to turn the floor over to Aaron, who's going to tell us the practical steps that organizations need to take in light of this decision. Over to you, Aaron.
Thank you, Lisa. As Bridget, David, and Lisa have pointed out through their remarks here today, the court's decision has provided some clarity, but it also raises some challenging questions for global organizations. While the standard contractual clauses have been validated, as Bridget pointed out, they've been validated with some very important caveats from the court regarding the rule of law in third countries. As organizations grapple with this decision, at the outset, I think that it's fair to say that there is a need for recognition that this is a highly political conflict of law situation at this point. And in some ways, this conflict requires a high-level political solution in order to be fully resolved. While that is certainly true, we think it is also true as a practice that an outsized focus on the politics of Schrems II, the United States, and the European Union is not really that helpful for global organizations whose day-to-day business reality is actually dependent on these data flows, as Lisa was just referring to. Instead, what we at Hunton believe is most helpful to global organizations right now is an evaluation of what it is they can control in the wake of this decision and doing everything they reasonably can in an effort to resolve these important questions raised by the court in this case, which my colleagues have been talking about. And as we work through our framework for resolving these questions, one important consideration for all of you to keep in mind is that the approach that your organization will take will, at least in part, be dictated by your processing role, i.e. controller or processor, and your location with respect to the data processing, i.e. EU or third country, right? Controllers and processors are impacted by this decision, as well as global companies with operations in the EU and those who are not established in the EU. And the tentacles of this decision reach all of them. So that's just something to keep in mind as we proceed with our recommendations here. Can we go to the next slide, please? So what can you control? In thinking about the constructive steps that you can take in the wake of Schrems II, the first step, I think, is happening here today, which is listening to David and Bridget and Lisa explain what this decision stands for. And as you've heard today, what it stands for are the propositions that the SHIELD is gone and the standard contractual clauses remain. But if you want to rely on the clauses, you need to ensure that the rule of law in the non-EU country doesn't require you to violate the standard contractual clauses and by extension, European law, right? Based on that understanding, the next step will require you to get your arms around the relevant data transfers emanating from Europe, okay? Some of you who have gone through GDPR compliance exercises will be in a better position than others when it comes to this diligence exercise. You can lean on your GDPR diligence and you can lean on your Article 30 inventories of processing to isolate those business processes that involve transfers of personal data outside of the EU. Clearly, the goal of this exercise is to develop an inventory of sorts that focuses on your transfers and includes within its scope the non-EU jurisdictions, the nature of the personal data involved in the transfer, and your processing role, controller, processor, with respect to the transfer, okay? That's just table stakes. Once you have your arms around the transfers, as Bridget pointed out, the Schrems II decision quite clearly requires you to conduct a transfer risk assessment with respect to the rule of law in the non-EU country where you'll be exporting the data, right? If that country has been deemed adequate by the European Commission, which has happened in some cases, at least for now, we think there's a defensible position that those transfers may continue. For all of those jurisdictions that have not been deemed adequate, which is most, you should seek to resolve a few key questions in your transfer risk assessment, which I've listed here in the slides, right? Those questions include, is the local government authorized to access European personal data that's been transferred into the country, right? If that's true, is this access actually addressed in local law, or is it something that happens kind of behind the scenes? If it is addressed in local law, does the law impose proportionality requirements on the local government to ensure that only personal data which is necessary for the purposes of collection is actually being processed by the government? And if yes, does the local law provide for the effective judicial remedies that Lisa was referring to in the shield aspect of the decision for the EU data subjects whose data is transferred, okay? As Bridget and Lisa pointed out in their remarks, the court's concerns about the US in the context of the shield part of the decision was really about the perceived lack of proportionality and the opportunity for effective judicial remedies in the US, or lack thereof, right? So in conducting the transfer risk assessment, what you're trying to do is understand if these same concerns apply in the relevant list of jurisdictions for you, right? In this assessment, let's just be frank, is easier said than done, right? It's almost certainly true that absent further guidance, two companies conducting an assessment about the same vendor in the same non-EU country will result in different outcomes, right? That is quite frankly the world in which we're operating until we have further guidance. But from a diligence perspective, and in thinking about the theme here of control what you can control, it will be important that you memorialize these findings and leverage this diligence in your decision making. Let's move to the next slide, please. Additional safeguards. Okay, so for many companies, the initial cut at the transfer risk assessment, using those questions I asked about sort of the rule of law, will yield unfavorable results in key countries, right? And as David and Bridget and Lisa have made clear, this is certainly true for the United States based on Schrems II, right? So this begs the question of next steps when data is transferred to a country where the answers to these questions are unfavorable, right? And to be crystal clear, that list of countries, unfavorable countries, quote unquote, is very likely to extend well beyond the United States once you've conducted that assessment, okay? The first option at this point, which won't be an option for many on account of practical and economic constraints, is data localization in the EU. That means putting a stop to transfers to quote unquote unfavorable jurisdictions and instead processing that data in Europe, right? Another safe option, although one that may ultimately change based on the logic of this decision, but hasn't changed yet, would be extending your data localization effort to those specific countries that have currently been deemed adequate, such as Israel, Japan, or Canada, right? None of this may be practical or feasible for all of your transfers, but it may be feasible for some. Once you move beyond localization, and I think this is the most important takeaway for organizations, you just have to accept that Schrems II results in a loss of legal certainty with respect to your transfers. You will be in the land of risk-based decision-making, okay? And as is the case with all forms of risk-based decision-making that extend well beyond global privacy law and that consume all of your day-to-day lives, professional lives, the goal for accountable organizations needs to be minimizing the residual risk as much as reasonably possible through mitigation efforts, right? And when it comes to data transfers, what this means is that you need to think about what additional safeguards that you could put in place to narrow the amount of residual risk to a level where you might be more comfortable with a decision to transfer personal data on the basis of standard contractual clauses, okay? Next slide, please. Risk mitigation. Okay, so when you're thinking about risk mitigation, right, the court mentioned the possibility of implementing additional safeguards, as Bridget pointed out, but it didn't really get into specifics with respect to what those might look like, which is fine. It's a court, that's not their job, right? We have been thinking about these additional safeguards in the context of administrative and technical safeguards that companies can put in place, and have included our current thinking in the slides, right? And as Lisa mentioned with respect to our thinking on the shield, obviously, you know, this is an evolving issue that could take weeks, months, or even years, and so our thinking will continue to evolve. But in a week, we've started to think through the sorts of things that we think our clients should consider, right? And this list includes data minimization, right? After you've gotten your arms around your transfers, thinking about how you might be able to reduce the nature and quantity of personal data that is transferred to the United States if possible. Another option might be some sort of obfuscation or encryption, both potentially during transit from Europe and at rest in the US or the third country. Obviously, this will not be practical in all use cases, but there could be transfers for which encryption would help, such as if you're using, you know, simply a vendor in the United States to store data on your behalf, and the data can remain in storage in an encrypted form. Obviously, that isn't going to work in all cases, but it certainly is something to think about as you get your arms around the facts. Another safeguard to consider is looking carefully at your data processing agreements, both controllers and processors. Right? Article 28 of the GDPR sets out highly prescriptive requirements, including some provisions related to audits and access controls within the processor that will be useful in a post-Schrems II world. Right? Also, in your data processing agreements, consider the value of adding some new contract provisions that might require reasonable challenges by the data importer to overly broad or inappropriate government requests for European data, right? Also think about liability in your contracts, right? Schrems II clearly ups the ante on potential liability exposure, special, you know, cost exposure for the party to the contract within scope of the GDPR, right? And liability issues in a contract setting are difficult to speak to in a webinar of this form because they're obviously highly dependent on the relevant facts and the relationship between the parties. But I think it's clear to say those liability provisions may need to be reevaluated in some cases, right? Another option, as Bridget spoke about, the court's decision was really a reaffirmation of the standard contractual clauses, which already require the importer to notify the exporter when they can no longer comply with the clauses, right? When this happens, which could result from government surveillance, there is a termination right in the standard contractual clauses for the exporter and a requirement for the importer to securely return or delete the data. Right, these specific obligations of the clauses, which many in the market have not focused on carefully as a historical matter, they need to be front and center in your DPA negotiations or your data processing agreement or data processing addenda negotiations, as the case may be, particularly in the wake of Schrems II, right? The days of sort of signing the model clauses and kind of disregarding their content to the extent any of you or other organizations were doing that clearly are over. Okay. Lastly, but certainly not least, as part of your transfer risk assessment, the parties are going to need to consider the exporters and the importers' actual and historical exposure to the types of government requests at issue in Schrems, right? In the US, this primarily means national security letters, FISA orders, in the FISA Section 702 program that is quite controversial, that David talked about with Edward Snowden, right? The laws that support these mechanisms in the United States are quite broadly applicable, right, as a legal matter. But as a practical matter, not all industries and not all companies are actually impacted, right? It should be understood whether both the controller and processor have, in fact, received these types of government requests in the past. If the answer to that question is yes, well, an uphill climb will ensue, right? Of course, how steep that incline will be will depend on the number and the nature of these types of requests. Okay, let's go to the next slide, please. Residual risk. After you've conducted your transfer risk assessment, right, and you've evaluated the additional safeguards that you can put in place to mitigate risk, you're left with your residual risk, right? You're going to need to think carefully about that residual risk and make a decision in the short term with respect to whether or not you're comfortable with the rule of law in the non-EU country, the additional safeguards that you put in place to mitigate risk, and the clauses themselves providing sufficient protection for the European personal data being transferred, right? In the long term or longer term, as the case may be, companies cannot execute these clauses and put them in the drawer, as I said, right? There's a number of issues that need to be resolved still, and we need to make sure that we stay close to emerging guidance from Europe. We expect guidance from Europe, and we hope that it will provide some additional answers to help global organizations resolve some of these thorny questions that my colleagues have discussed here today, right? Lastly, and this is just a word to the wise, if you move towards standard contractual clauses and away from the shield, which you should do, keep in mind that a new version of the standard contractual clauses are expected in the near term. And those clauses, the ones that exist today, have not really worked in perfect unison with the GDPR. So this has long been expected. But it is possible that some of the issues raised by the court will be addressed in the new version of the standard contractual clauses. We wouldn't recommend waiting for the new clauses to come out for most organizations, but instead understand that there likely will be two waves here, right? The first wave to get into the current standard contractual clauses, and then just know that you might have to replace them with new standard contractual clauses as appropriate when they're published. Thank you very much. I'll turn it over to my good friend and colleague, Bojana Bellamy, to discuss the weighty policy issues raised by Schrems II. Thanks.
Thank you very much, Aaron, and hello, everybody. Let me just, in the few minutes that we have remaining, just remind you of some of the wider and bigger, perhaps more strategic discussions after we've heard quite a lot of practical discussions from our partners here. So, and I'm sorry if I'm rubbing salt again with some of the wounds, but some of these messages are not going to be easy. So can you just show the slide, please? The first point I wanted to share with you is that what we have learned through Schrems II decision judgment is that really the lesson of GDPR is going to trump law. And what I mean by this is that what the law says is what the law means, and that's how judges interpret the law. So all that contextual and sort of compromising kind of interpretation that we privacy officers work with, I think that is really now to put a little bit in the background, because judges really interpret the law incredibly literally, and of course, including the standard contractual clauses, they're just reminding us what we should have been doing all the time. So the time when we were just signing the standard contracts and not doing anything, that time has passed. There's going to be much more need to be accountable. And of course, this means, and this applies to everything else in GDPR as well, right? And this also applies to everything else that Europe is going to be passing in terms of digital privacy regulation or AI regulation. Everything that is tainted by human rights, fundamental rights, paintbrush is going to be very, very literally interpreted and strongly by the court. Second point is that really businesses have to be aware and ready to face more conservatism in the way that Commission behaves, in the way the data protection behaves. These cases have now been given really a reminder Irish DPC has sought for, that it was their duty to look into these transfers, even though they were based on the adequacy such as privacy shield, or even though there are standard contractual clauses, right? And so that worries me, that these other progressive concepts of GDPR, such as certifications for data transfers, or BCR to be used between two groups of companies, joint economic activity, that's in GDPR, or bridges with other regions, such as APEC GDPR, or even ISO standards, they're not going to be enough. Why? Because the question will always be, do they provide these three key things, or perhaps four key things: substantive provisions, appropriate safeguards, effective judicial remedy, and effective exercise of individuals' rights. Like, those four things have to exist, right? The third point is the data flows are going to become, again, absolutely top compliance, commercial and strategic issues for many companies, because companies are going to be dependent on uses of third-party service providers. They're going to be dependent on use of data. Those who are driving their AI and data strategy will have to be able to share and access data globally. It gives them opportunity and freedom to operate, freedom to grow. So you have to raise this strategically at the really highest echelons of your company, that unfortunately we live in these times of legal uncertainty, and it's only going to get worse, so we have to get there. So your leadership needs to be aware of this. The other implications of business is about the need to really practice and keep doing all the time that risk-based approach and accountability. And Aaron and Bridget talked a lot about this as to what that transfer risk assessment may entail. It may be part of your DPIA, right? It's going to be different if you're doing controller to controller, controller to processor. It is going to be different based on data. It is going to be different based on, if it is HR data, it's probably very different than if it is communications data, banking data. So you have to be ready to assess these risks and likelihood and severity of the harm to individuals because of the national security and national surveillance provisions as well. And of course, accountability, how you do that, and what measures you as a controller, exporter, and a recipient processor or another controller are going to put in place to mitigate that, right? You cannot, of course, avoid ever the application of the national security provisions, but you can mitigate the likelihood of these cases actually taking place or impacting your transfers, wherever that is possible. Some may not be, and for those, then the question arises, what do we do differently? And that's why I'm saying here as another takeaway that really data location does matter. And I'm sorry about that. You know that I've been a buccaneer. I wanted to see global data flows. We know the global data flows are bringing economic prosperity. COVID has taught us that that is the case, but data location is going to matter. I'm going to probably not surprise you by saying that we're going to see a number of commercial service providers localizing their services more, and you know, that's not great for all of us and for the economy, but sometimes that may be the only way forward. So let's now speak, if we can go to the next slide, please, very briefly on some broader policy considerations as well. So first of all, Brexit just has got more complex and probably interesting as well. Complex for the reasons that Bridget discussed, because UK may not be the recipient of an adequacy decision, so will be in the same boat as the US, India, China, South Africa, or any other country really, in terms of assessing the adequacy or essential equivalency of that jurisdiction. But it might be also more interesting because we may see perhaps a little bit braver and more different approach from the UK, slightly tangentially departing perhaps from what Europe is doing in terms of data flows. Because UK will have to interpret GDPR as well, because UK has got GDPR, but it just may be slightly different. So it could be very interesting as well. But from your perspective, data flows to and from UK are going to be impacted based on this at all as well. Now, European data protection authorities, I have always said GDPR dealt them a really tough hand. They have got huge amounts on their plate. Now they're going to have even more, right? It is absolutely clear now that the court is reminding them they've got rights to not only assess the transfers, but also suspend or prohibit these transfers where there are no appropriate safeguards. So the DPAs are going to be having to do these assessments just like you are going to have to do them. And so there is this massive need, as Aaron has said, to actually maybe try to do this together and to think about some kind of joint ways in which we can be assessing this third country appropriateness. But remember, it always has to be done in the context. And I think that is really very important to say. And context matters, and context does differ a lot. But still, DPAs will have to do it. Still, we will be very concerned not to have diverging decisions from the DPAs, and the court reminded about this as well. So it is very likely that all of these decisions, once we see them, and we are going to see one probably in Ireland, right, first, so it is likely that these decisions will be subject to Article 60 on cooperation for the processing cases, and then Article 64 as well, because ex officio, the DPA may submit that decision also to the opinion of the board. And I do hope that they do so, because we need absolutely single way of looking at this from every single DPA. And so it's not just about guidance, but it's also about, dealing with some of these first cases, setting some precedents, being transparent about that as well. And that's what I'm going to be looking from DPAs. My last point is really global spillover. And I'm sorry, but this is going to have impacts not just on the transfers to the US, but transfers to everywhere else, all of the key destination countries where processing takes place. All the existing adequacy decisions, if you're relying on them, are going to be shaky, right? Apart from Japan. Why? Because Japan's decision does include this consideration of essential equivalency and national security and surveillance post-Schrems I. There's going to be mounting pressure for other countries to copycat the EU approach, right? And I remind some of you who've been following Brazil, when Schrems I came, Brazil kind of said, should we do the same? And, many other countries were asking these questions as well. And I worry that after Schrems II, there are going to be renewed calls for countries to stop data transfers or suspend them or look into them based on national surveillance provisions. And then finally, it is going to also encourage those countries that are pushing for data localization and data sovereignty in other parts of the world. And that to me is really a great shame, but it's inevitable. So what do we do? I have talked a lot about, and Aaron has talked about, of course, the need for companies to assess and do these risk assessments themselves. Lisa talked about the negotiations between EU and the US. They are persisting, and they might yield something, but it is going to be a high bar, so they have to pass. But also there is OECD. OECD is actually reviewing these guidelines, and as a part of this review, Japan and some other countries have actually put the question of governmental access to data on the agenda of the OECD. I sit at the advisory board, expert group there, and this is now being discussed, and I hope we will tackle this as well. What else can we do? CIPL will try to do. I'm looking forward to working with CIPL members and also DPAs to maybe, and Hunton, of course, lawyers, to come up with perhaps what is appropriate safeguards in this risk assessment, transfer risk assessment may look like. What kind of safeguards would be acceptable to a data protection in particular contexts. Other than that, give us ideas, please. We would love and welcome any way in which we can impact these important policy discussions. But as I say, the world has just got a little bit more complex, and I hope this gives you a chance also to raise these issues really at most senior levels of your company, because this is the time for your leadership to get involved. It's time for your public policy to support your privacy office as well, and frankly, to also make some démarche with different governments to actually settle this once and for all. So thank you very much. Back to you, Lisa.
Thank you very much, Bojana. So Bojana said that the world has gotten a little bit more complex. I will repeat the words of a UK barrister in a blog post this week, who said, "This is not a fine mess, it's an awful, almighty mess." So thank you again for joining our program. Please visit our blog at www.huntonprivacyblog.com. We'll be posting on developments on this issue, and we look forward to having you at future events. Thank you for joining us.